On the 25th of November, the SRA brought into effect changes to the Solicitors Conduct Rules, which were the first change to the conduct rules since 2011, and we need to train you with regards to those changes and also corresponding changes to the Solicitors Councils. The way we're going to do this is there was some training materials prepared by DG Legal, and I think the quickest and easiest way to cascade the information is to do one of these videos where we'll go through the training material and send around the corresponding document, so you'll have all of the materials to refer to the whole document, but we'll try and focus on the stuff that is most relevant to us. One of the main changes is that there are now responsibilities on individuals rather than firms, and those responsibilities extend to people employed by law firms and not just solicitors. That really does mean that everyone who is engaged with Tucker Solicitors LLP, they have individual responsibilities, and therefore they need to understand the framework for the Code of Conduct and the Solicitors Accounts Rules. Obviously some need to understand certain details more than others, but there's a base level that we all need to be aware of, and we'll try and focus on the relevant parts of the regulation which relate to different people as we go through. So fundamentally what the SRA have done is that they have changed the Code of Conduct from a lengthy document with lots of specific rules and condensed it into a revised document which focus on the principles which will govern us rather than lengthy specific rules which we have to comply with. And the same is true in terms of the Solicitors Accounts Rules. Of slightly less importance, I hope, there are also additional changes which include the fact that if you do now appear before the Solicitors Disciplinary Tribunal, they may make a finding against you on the basis of the civil standard of proof, i.e. the balance of probabilities, rather than the criminal standard of proof. So let's go to the principles, because these are really the core of the Code of Conduct. There's an important change, I think, to what we used to refer to as Rule 1, which was to act in the best interest of the client. The best interest of the client does still remain one of the principles, but you can see it's actually principle number 7. Principle number 1 is that we should act in a way that upholds the constitutional principle of the rule of law and the proper administration of justice. If we look at some of the other principles, what they're really getting out here is our behaviour, that we act with independence, with honesty and with integrity, and there is a specific focus. It's always been a sort of implicit focus, certainly for the last number of years, but a specific focus on equality, diversity and inclusion. And in practical terms, let's just pick up one of the examples that DG Legal give in the context of applying the principles. If a person is found to have stolen money from a client, they will have failed to meet principles 1, 2, 4, 5 and 7. Yeah, clearly it's not upholding the principle of the rule of law and the proper administration of justice. It doesn't really uphold public confidence in solicitors if we steal clients' money. It's not very honest. Obviously it doesn't contradict principle 3, to act with independence. We violated the principle to act with integrity, and clearly it's not in the best interest of the client. So as I've already said, there's a change in that there is no longer a single code of conduct. There are now 2 codes of conduct. There's a code of conduct for solicitors' firms, which is 6 pages in length, whereas the code of conduct for individual solicitors is now a separate document, which is 8 pages in length. So in any event, they've reduced the total length of the conduct rules, but the focus is more on the behaviour of individual solicitors than it is necessarily of firms. And like I say, that does broaden out to people who are employed by law firms. The rules specifically refer to the fact that the rules do apply to people who aren't qualified solicitors. So we're going to look at some of the specific rules that relate to the conduct for solicitors, but we're going to focus on just a few of them, those which are probably more relevant to us. So the idea of maintaining trust and acting fairly. We've still got to deal with the issue of client money, and we'll go into some detail on that because that's something we do need to improve on. Those sort of old chestnuts of conflict of interest and confidentiality and disclosure are still very important and central to what we do. And there's a section on complaints handling, which I think is probably also worth going through. So let's start with the principle of maintaining trust and acting fairly. I think the important point about this is the extent to which the principles that relate to solicitors or people employed by solicitors' firms do not just relate to the work you do within the law firm. This idea that solicitors, those employed by law firms, must maintain trust in the process of upholding the rule of law means that these principles will be applied to what we do outside of the law firm, with Mr. Mahmood being a recent example under the old rules, where he was fined £25,000 and suspended for practice as a result of posting anti-Semitic opinions and views on his Facebook account. And have a look at the rule relating to dispute resolution and proceedings before the courts. There are some statements here which are so blatantly obvious that we hope they don't need saying, but there are also some statements in here which do extend into that territory I was talking about, where your duty to the court and your duty to the client are now in balance. So you cannot just rely on saying that you are seeking to act in the best interest of the client. Anyway, starting at the top, you do not misuse or tamper with evidence. Please don't do it. They take these things very seriously. 2.4, you only make assertions or put forward statements or submissions which are properly arguable. So that's the point I've been making about not just putting forward any old submissions that the client would have you make. And then 2.7, you draw the court's attention to relevant cases and statutory provisions or procedural irregularities which you are aware of. Again, the danger here is that you run the risk of being in conflict with your client if you are exercising your duty to the court to sell them something which ostensibly could put you back into conflict with your client. So there are issues here which are going to cause concern and mean that you have to sort of weigh things up in a different way than you might have done in the past and take advice where necessary. So an extreme example of that, and there seemingly had been a practice of certain immigration lawyers bringing cases to court to judicially review them. They knew that those cases were bound to fail, but those cases were being brought simply to extend the time that someone was able to remain in the country. Previously, a lawyer may have asked that they were acting in the best interest of the client. That clearly now runs contrary to your duty to the court, and we would expect to see that kind of behaviour come before the Solicitors Disciplinary Tribunal in the future. I think we can whiz through service and competence relatively quickly because there's nothing really that's changed here. I think the one that is really important for us is that we only act for clients on instructions from the client or from someone properly authorised to provide instructions on their behalf. So we do need to be vigilant when talking to wives, girlfriends, husbands, fathers, mothers, that we've got the actual, preferably written authority on the file to confirm that we are able to take instructions or even to just impart information to those third parties. Otherwise, the obligations here are around competence and supervision. There clearly is an issue in terms of managing files, that file reviews are an important part of supervision, and or monitoring incoming and outgoing correspondence. From the point of view of a solicitor, you can't really delegate that responsibility. It's not sufficient to say, I gave that to this supervised paralegal, but they made a mistake. The responsibility remains with you. client money and assets. We'll likely come back to this topic when we look a bit more closely at some of the Solicitors Accounts rules. You properly account to clients for any financial benefit you receive as a result of their instructions. You safeguard their money, and we only hold client money in accordance with the relevant rules. The rules relating to referral fees remain. In civil cases, they're relatively complicated, transparency being the primary issue that we would need to deal with if we were dealing with any referral fees. In crime, it's much more straightforward. It's still unlawful to make a payment or to receive a payment relating to a referral in respect of a matter which is the subject of criminal proceedings. The rules on conflict of interest remain. Simply, we must not act if there is a conflict of interest or a significant risk of a conflict of interest. Obviously, this arises most commonly for us in the context of co-defendants. We need to be alive to the issue that even if then there is not ostensibly a conflict at the outset of a matter, that doesn't mean that that will remain to be the case. If we are acting for co-defendants under the rules, it would be preferable, in fact under the rules it's quite clear that it's a requirement that all clients should have given informed consent, given or evidenced in writing, to us acting for more than one person where there is a conflict of interest or a significant risk of conflict of interest. So where we are acting for co-defendants, it would be beneficial if we could get something from both defendants on their respective files to deal with the fact that we're acknowledging the risk of the potential conflict and that the clients have given their informed consent for us continuing to act in that way. So moving on to the next part of Rule 6, confidentiality and disclosure. Obviously the rule of confidentiality continues to exist. We cannot disclose any information about a client unless the client consents. Obviously you expect to see this having an increased emphasis under GDPR. So the references in Rule 6.4 to informed consent given or evidenced in writing. I suppose the important thing about evidenced in writing, it doesn't have to be something from the client that is written and signed. It could be an oral consent that is recorded by us in writing on the file. However, obviously it's far preferable to have something from the client which is signed by them. Under 6.4c, there's this idea here that if you have a reason to believe that serious or physical mental injury will be caused to your client or another if information is disclosed. So here, although there's a duty of full disclosure to your client, that duty is tempered to a certain extent by your own judgment as to whether it's actually in the client's best interest to receive that information. Obviously that's a pretty narrow exception, but if you think that disclosing information will have the ability to or potential to cause serious physical or mental injury, then you do have an entitlement to withhold that information. The rules don't make any specific mention of another scenario that we do have from time to time, which is where we have information about a client. That client is possibly at risk of self-harm, possibly suicide, and we have that judgment to make as to whether or not we disclose those issues to a third party in order to try and prevent our client from harming themselves. There isn't anything in the rules which helps us with that scenario. However, I think that the balancing act that the principles sort of set out, I think make it more likely that we would disclose in those circumstances, albeit in those very limited circumstances where we have come to the view that the obligation on us to make a disclosure to a third party is so great that it outweighs the duty of confidentiality to the client, and the serious risk of harm to themselves would probably be one of those scenarios, as we've done in the past without much support or guidance from the SRA. Fair to say there isn't any support or guidance from the SRA in these rules either, but I think the balancing act that the rule sets out in the round makes it slightly easier for us to argue that that's a common sense and correct position for us to take, provided it is used in limited circumstances and properly recorded on the file. For the most part, Rule 7 is probably a concern of management rather than individuals, although a reminder that these rules do relate to individual solicitors and individuals who are employed by solicitors' firms, so the obligation to cooperate with the regulator does impact directly on you personally. As a rule, that will mean, I suspect, passing it up the chain if something needs to be reported to the SRA. But such referrals will include matters to which you are personally subject. For example, if you are subject to any criminal charge or conviction, insolvency or such like, you do have the obligation to report, albeit you may choose to report through the firm as opposed to directly. And I suppose the other biggie here under Rule 7 is that you are honest and open with clients if anything goes wrong. And if a client suffers loss or harm as a result, then you put matters right, if possible, as quickly as possible. There's a real tension here with our obligations to the client and our regulatory responsibilities and our responsibilities to our insurers, who, I suppose, analogous to a car accident. If you shunt someone in your car, you're not supposed to get out of the car and say you're sorry, because the insurers can then turn around and say you shouldn't have admitted liability. So there is a slight tension here, so I would urge anyone to seek advice if they're in a situation where something has gone wrong on a file and we think we need to take steps in order to remedy that. We do need to do so in a way that's sensitive to our insurance position, just in case we need to rely on the indemnity policy. But fundamentally, the culture under the regulations is not one of digging a large hole and burying anything that's gone wrong. It is a culture of openness and an attempt to right any wrongs. And you can certainly see that in the way the SRA have regulated certain situations we've been in the recent past, where we've made disclosures of quite serious breaches of the SRA Code of Conduct, and they tend to turn a blind eye on the basis that we were good enough to report ourselves, so we're probably good eggs, as opposed to when you hide something, they find it, and then they take the view that because you can't be trusted to report when things go wrong, that you should be subject to much tighter regulation and much more severe punishment than you would be if you were in that self-reporting culture. There's a whole section under 8.1 relating to client identification, that we must identify the client we're acting for. I'm going to skip over this because in reality this is predominantly aimed at those doing transactional work, and this is to do with money laundering much more than it is to do with criminal defence or civil claims against the police or other state entities. No need to be blasé about it, though there is an obligation in there in the rules. Big section on complaints handling. Again, I suppose the emphasis here would be that the obligations are yours personally, albeit within the context of the firm. If you pass them up the chain to relevant supervisors or complaints handlers, then they can have the responsibility for dealing with the formal elements of the complaint. Again, here we're in that culture of transparency and openness, and the attempt to deal with things in a transparent way rather than hiding them. But nothing really changed in the complaints handling regime. And then the last part of the rules for individuals, client information and publicity. I suppose the important things here, you give clients information in a way that they can understand and so they can make informed choices. Importantly, we give them the best possible information about how their matter will be priced, both at the outset and as matters progress. This is important in civil legal aid because, particularly where the statutory charge applies, the obligations to keep clients updated as to costs is still central to the Code of Conduct, and obviously any privately funded work needs to be treated in this way as well, with clear transparency as to costs at the outset and as the matter is progressing. I suppose another example of this, which you may or may not be aware of, relates to the transparency requirements. We are now required to publish certain information on our website relating to prices that we're going to charge for specific transactions. Insofar as Tuckers is concerned, that only really relates to motoring offences, for summary only offences, and to the immigration work we do. They are all published on the website, but there is a distinct possibility that we're going to see an extension of the price transparency regime, and it may be that we have to be more transparent about pricing for private matters in more complex criminal cases in the near future. So bearing in mind, we've been through the rules which relate to individuals. I'm not going to labour the rules which relate to firms, which are predominantly the concern of the management team in order to implement those. However, as you would expect, there's a large level of convergence between the two. The firm has to act in a way to maintain the trust and confidence of a client. There are now specific rules in place relating to compliance and business systems. These didn't exist before in the Code of Conduct. Not surprisingly, these largely mirror the compliance and business systems that are set out in something like the Lexel standard. So I'm reasonably confident that we've got these in place, provided we continue to comply with that standard. Under Rule 3, as you'd expect, there's a corresponding duty on the firm, the same as for individual solicitors, to comply with the SRA and other regulatory bodies. Rule 4 is a corresponding duty relating to service and confidence, and this will certainly cover the firm's responsibilities with regards to things like file reviews, handling complaints, supervision more generally. 5 is a corresponding duty to look after and account for client money, and under Rule 6 is a corresponding duty relating to the conflict of interest and also the issues of confidentiality and disclosure that we've already discussed. So if that covers the Code of Conduct, we then have the Solicitors Council rules, the vast majority of which I'm not going to go through with in this training session. Obviously it's a different matter for the accounts and billing team, but insofar as most people are concerned, and specifically where we are doing more private work, I just want to make specific reference to the specific rules so that we're absolutely clear of what's going on here. So client money must be kept separate, that's old news. Where you're holding money, and some or all of that money will be used to pay your costs, you must give a bill of costs or other written notification of the costs incurred to the client or the paying party. Importantly, this is not just profit costs. If you are paying a disbursement, say for an expert, and that is coming out of client money, the way that this is done is that we raise a bill, a disbursement only bill, we move the money from client to office account, and then we pay the money out of office account. That is a movement of client money, and therefore not only does the system require a bill, the rules require that the bill must be given to the client or the paying party. For 3B, this must be done before you transfer any client money from the client to the office account, and any movement must be for the sum identified in the bill of costs or the written notification. So these are specific rules requiring us to make sure that we document the movement of money from client to office account. And that doesn't mean just creating a document which sits on the file. The specific obligations are to make sure that the client gets a copy of that document and that the client gets a copy of that document before we move the money. So while I've got your undivided attention, I'd just like to do a few reminders in terms of training we have had in the past, but where behaviour isn't necessarily where we would like it to be. So the old favourite, our GDPR policy. Can I just remind people of the rules around creating passwords? All passwords created by the firm's employees should follow the below guidance, so 8 characters or more, 1 uppercase, lowercase, should not be easy to guess, so password is always the old favourite. Things like consecutive passwords, elephant 1, elephant 2, etc. should be avoided where possible. think the key here is that we are happy for people to use a password keeper if that is their preference. LastPass or RoboForm are available. You can use this link in order to go to the training materials to register for a LastPass account. You can use LastPass within your web browser and on your telephone, so it can unify all your business and personal passwords without having to do that thing where you write them down on a piece of paper, someone finds a piece of paper, and with it your life. So let's get into disposal, because again we're sort of struggling with the amount of discs and media we receive. We've got broadly three types of media. We've got the hard disks on the laptops. I think you need to leave those to us to destroy. But then the real issue is we've got the portable media, the disks and USBs. I think when we get to the end of the case, if you want to send those into billing, which is helpful in any event, then again we can try and destroy those centrally. The big danger, I suppose, given particularly people working more and more from home, is paper coming into existence, and that paper being at people's homes. That documentation must be shredded using a certificated secure destruction provider. In reality, the only sensible way to deal with this is to bring the paper into the office in order for it to properly be destroyed. And then just very quickly, let's just deal with the archiving and retention issues. In terms of individual users, my real worry is material being saved to the hard drive of a device relating to clients. At the end of the case, that material should be destroyed. Yeah, it should be saved within the case management system. That's fine, and then we can rely on our normal retention periods if you need access to that for a certain period. But where it is already saved, particularly already saved to the case management system, there is no requirement to retain a copy on your hard drive, and indeed you should not do so. Okay, my next hot topic relates to the use of the correct precedent when instructing experts, and this relates to any application. This isn't just crime, this is prison law, PAD, etc., etc. We have a letter in the system, like I say, which relates to all of the applications, which is letter to the expert, read terms and conditions. There are two really good reasons to use this letter. One is that it has content relating to our GDPR compliance, and two, it has content relating to our terms and conditions of payment. Please, please, please use this precedent in order to ensure that those two compliance requirements are met. Obviously, the rest of the template can be amended as you see fit in order to provide relevant instructions to the expert.